Hi, this is Sapna and I am going to describe in this video about the introductory part of a group visit to one of the courts in Melbourne. We were a group of 5 students, namely Nicholas, Kaitlyn, Sapna, Fahimeh and Laura. This presentation is going to include 3 key topics that will be covered. First is a thorough and accurate description of the court and associated legal process, which will be covered by me, Sapna. The second topic will be a thorough description of the observed legal matter and relevant legislation which will be covered by Kaitlyn and Fahimeh. And the third topic is discussion and critical analysis, which will be covered by Nick and Laura. The court that we chose to visit was Broadmeadows Magistrates Court. And before discussing about the visit, I would like to take a brief introduction about a magistrates court. So in Australia, every state and territory has a magistrates court, and it is also called as the bottom level court or the lower level court. At this level, no jury is involved and the magistrate hears all the cases. Basically, it has 6 divisions and its jurisdiction involves criminal, civil, family and industrial related matters. Let us now move on to understanding a visit to Broadmeadows Magistrates Court by our group. Some basic facts and figures. So Broadmeadows Magistrates Court is one of the 51 Magistrates Court of Victoria. It falls under Metropolitan Magistrates Court. Basically, there are 2 types of Magistrates Court in Victoria. So the first one is Metropolitan Courts, which are 10 in number in Victoria, and there are 41 remaining country courts in Victoria. As far as the jurisdiction of Broadmeadows Magistrates Court is concerned, it deals with criminal matters, civil matters, intervention orders, and bail support. In relation to criminal matters, it attends to all summary cases, which are defined as generally the less serious ones. It deals with many indictable cases, which are the more serious cases. And it also conducts committal hearings, which are conducted to decide if the case deserves a hearing in a high court or not. The court basically starts at 9 o'clock in the morning and it runs until 4:30 in the evening. Generally, 6 courts operate in the Broadmeadows Magistrates Court and we attended the court number 6. It is the criminal division of the Magistrates Court related to the criminal offences committed by children. A visit to Broadmeadows Magistrates Court layout. Let us basically understand what the court layout was. So as we can see, the top left section of the room was devoted to the magistrate's chair, and in right front of the magistrate chair sits the bar table, which was attended by the defendant and the prosecution. Right behind the defendant is the public gallery, and in front row of the public gallery was sitting the accused with their supporters. As we can see, right besides the magistrate sits a bench clerk who happens to take care of all the administrative work that is going on in the court. And the top right section of the room is a witness box, and in front of the witness box is present a dog. A dog is basically there in a court where defendants generally sit. But in case of our court visit, we didn't see any children going and sitting in the dock. They were sitting behind the defendant with their supporters. And the rear section of the room is devoted to the public gallery, where the observers, the audiences sit and attend to the hearings. The next section of the slide contains the personnel present at the hearing. So we had registrars in the courtroom who perform all the administrative work of the court as we discussed. They are very essential for the day-to-day operations of the court. For example, processing court documents, answering queries, and bench clerk duties. Then comes magistrate, who is called a judicial officer, who decides the cases and imposes sentences, and also provides directions for the laws. Then was present the prosecution, which generally in case of a magistrate court is the police, who lists the type of charges involved and prepares charge sheet accordingly. And then there were defendants present in the courtroom in the form of defense lawyers or legal aid who represents the accused as his or her lawyer. If we talk about others who were present in the courtroom, so it was the party involved in the cases. For example, the accused, here they were children who were charged to have been guilty. Support for the accused in form of their guardians, their parents, the siblings of the accused, the social worker of the accused, youth and justice worker of the accused, and the spectators and audience in form of university students and some other people as well. If we'll talk about the legal processes observed in the courtroom, after the magistrate enters the courtroom, everyone stands up, bows to the magistrate. The magistrate is being addressed by saying, "Your Honor," and magistrate bows back to everyone, sits, and the audience sits following the magistrate. All the cases being heard were mentions hearing. A mention hearing is defined as the first or subsequent hearing of a case in the magistrate's court. The registrar announces the case numbers, such as case number 1, case number 2, to be heard. In all the cases observed, the case started with the prosecutor initially stating the charge sheet and the related matter. The police prosecutor's allegations were followed by the defense lawyer or the legal aid, presenting the facts, figures, steps, and measures taken by the accused in relation to the allegations. The magistrate asks questions and considers opinion of the parties involved. On the basis of listening to both the parties, discussions and feedback, the magistrate differs or decides the case. The next section of this presentation will be covered by Fahimeh and Kaitlyn. Thank you so much.
During our time at the Children's Criminal Court, we watched a range of cases. We chose 2 cases to focus on, as the others we saw were deferred for a later time. The 2 cases we chose were the second and fourth trials. The second trial we saw was about a young man who was charged with robbery and violent behaviour. The youth was described to have been brought up in a difficult childhood, including a difficult family situation and growing up in a violent home. He was said to have then been brought up with his grandmother, who passed away when he was 14 years old, and since then has been living in resi care. During his trial and sentencing, the magistrate acknowledged his hard work since his previous trial. Included in this was meeting the requirements set of his previous trial. This included attending drug and alcohol counselling and also stop using drugs. And the magistrate found that he has protective factors, including in this was looking for work, which could potentially be working with his brother in construction. The result of this trial found that the accused was sentenced to a 6-month probation order, in which the youth justice worker also recommended continuing drug and alcohol counselling. The magistrate recognised this was a good outcome due to the positive aspects that the young person showed. The fourth trial we saw involved a young man who had broken up a house party fight by using a glass bottle. The violent act had inflicted serious physical injury on another young person's face, leaving the other individual with scarring. The defendant wrote a letter of apology to the victim and also attended a 6-week group conference. The magistrate recognised that this was the defendant's first offence and that he had apologised, but also wanted him to understand how serious of an act this was, and how also seriously it had impacted on another individual. The magistrate then asked the defendant 2 questions to judge how the defendant was understanding what he had done and used this as a base of his sentencing. The result of this included an extended good behaviour bond, of which approximately 20 hours of volunteering at the local Vinnies was expected. The volunteer work was to be done during school holidays to not impact on his education, and the magistrate said that the point of the volunteer work was to give back to the community.
Today I'm going to talk about the key parties. The first one is the defense solicitor or duty solicitor, the person who represents the accused in court. The second one is prosecutor, the person who appears in court to present the case against the defendants in a criminal hearing. Case in the magistrate court and children court are usually prosecuted by a police officer. The other point is that barrister, a legal advocate who is briefed by a solicitor to present the defense or persecution case in a magistrate court and children court. Magistrate, the person who hears cases and makes the decision in the magistrate court and children court. They decide what happens to a case, where a case will have to go to another court or be put off until another day, where the defendant is guilty or not guilty, and any penalty that will be given to the defendant. Registrar, the manager or administrator of the court. It will be a registrar or a deputy registrar who will assist you at a court counter. Now I'm going to talk about the role of social work in child protection. Child protection system responds to children who have suffered or are likely to suffer significant harm as the result of abused and neglected. In other words, social work have a central role within the local authority with the duty to promote, support, and safeguard the well-being of all children in need in their area. And insofar as in consistent with that duty to promote the upbringing of children by their families by providing a range and level of service appropriate to children's well-being needs. Furthermore, social work together with the police has a legal responsibility for investigating child protection referrals to and coordinating and integrity responses. Under the Children Act, according to 1995 Act, social work also has a responsibility of assessing the needs of children identified as being children in need. In fulfilling this responsibility, social work has a member of key roles. These include investigating referrals, coordinating multi-agency risk assessment, arranging child protection, case confidence, maintaining the children protection register, and supervising children on behalf of the children hearings. Now I'm talking about the youth justice worker. The Department of Justice and Community Safety is responsible for the legal supervision of young people in the criminal justice system. The department's youth justice service provides programs and resources to assist these young offenders to develop the knowledge, skill, and attitudes to manage their lives effectively without further offending. Through supervision, offending-related programs and linkages to appropriate support services, the youth justice service promote opportunity for rehabilitation and contributes to the reduction of criminal in the community. And also, the youth justice service objective are two. The first one is that where appropriate support the vision of young people charged with an offense from the criminal justice system. The second point is that minimize their likelihood of reoffending and further progression into the criminal justice system through supervision that challenges offending behaviors and related attitudes and promote pro-social behaviors. The other point is that provide supervision and rehabilitation through the provision of case management and other services to assist young people address offending behavior and support successful reintegration into the community. The other point is that work with other services to strengthen community-based options for young people, enabling an integrated approach to the provision of support that extend beyond of court order. And the last point is that engender public support and confidence in youth justice service. Thank you for listening.
All cases heard within the Children's Court, including the Criminal Children's Court, involve minors. Due to this, the legislation relevant to these matters is the Children's Youth and Families Act 2005. This act was developed in 2005 in order to provide a service to support children and their families. The act also aims to provide protection of children and to make provisions for children found guilty of offences. Alongside of this, the Act also continues to be a specialist court that deals with matters relating to children. During case trials 2 and 4, we had a range of information in which a legislation later was found under the Children's Youth and Family Act. Relating to case 2, the first legislation relative to the matter was number 380. This was that a court may order probation. The young person during this trial was ordered to a 6-month probation order. This legislation states that, firstly, if the court finds a child guilty of one or more offences, whether indictable or summary, the court may, with or without conviction, place the child on probation for a specified term. These terms include not exceeding 12 months or not exceeding 18 months if the offence or one of the offences is punishable by imprisonment for a term of more than 10 years, and not exceeding beyond his or her 21st birthday. Secondly, the court may make an order under subsection 1 if the child has consented to the order being made. Still relating to probation, legislation 381 states the conditions of probation orders. So this legislation says that if a person is replaced on probation, the probation order is subject to the following conditions. So firstly, the person must report to the secretary within 2 working days after the order is made. Secondly, the person must, during this period of probation, report to the assigned youth justice officer as required by the youth justice officer. And thirdly, the person must not reoffend during the period of the probation order. Finally, the person must not leave the state without written permission of the secretary. Within Case 4, the first legislation was number 367, the Good Behaviour Bond. This was relative because the defendant received an extended good behaviour bond with volunteer work within this. The legislation states that if the court finds a child guilty of an offence, whether indictable or summary, the court may, without conviction, adjourn the proceedings if it appears the exhibit to do so. Having regard to the following circumstances, including, firstly, the nature of the offence and the character and antecedents of the child, and whether or not the child pleaded guilty. Within this trial, the magistrate took the fact that the young person had interacted in group conferencing, and under the Children, Youth and Family Act, that comes under legislation of 362, matters to be taken into account. Within this, it states that if a child has participated in a group conference and has agreed to a group conference outcome plan, the court must impose a sentence less severe than it would have imposed if the child had not participated in a group conference. It is based on the restorative justice principles and aims to help the young person avoid further or more serious offending. The group conferencing process attempts to strengthen the young person's family and community supports and identifies ways of restoring the harm that was associated with the offending behaviour. A group conference can be attended by the young person, their family and their supports, the victim and or their representative, their family and the supports of the victim, legal representation of the young person, the police informant, so this is the police officer who laid the charges, and community members and the convener. So the recommendations of the group conference can include assistance and support for the young person in areas such as education, skill development, employment, and counselling, and also ways of dealing with the offence. This could mean that the young person apologises, pays for part of the harm or the damage that was a result of the offence, and or makes a donation.
Cool. So, looking at the due process and natural justice part of it, Nick, do you think that the due process occurred in the cases that we observed in court?
Yeah, I think it was observed. The judge gave the defendants a chance to speak, and they had lawyers present representing them. And due process is about looking at making sure that there are processes in place to ensure that there is a fair trial and that everyone has the right to a hearing.
Mm-hmm.
And that's obviously covered under the Criminal Procedure Act in 2009.
Mm-hmm.
And that states that, due process and legal representation has to be considered in every case. But even more specifically in the Children, Youth and Families Act, as we observed criminal division matters from the Children's Court, that all young people who are facing trial need to actually be represented with a lawyer. It's actually one of the legislations as a part of the Children, Youth and Family Act.
Mm-hmm.
And if that isn't actually done, then the court has to postpone the hearing until a lawyer is present so that the young person is represented.
Yeah. So in terms of the legal aid funding in Victoria then, so how can the effects of changing legal aid funding affect the due process in cases involving young people?
Well, it's a really interesting one because legal aid are the main body that actually provides lawyers for young people. They're the ones that the department actually contracts out to represent young people.
Mm-hmm.
And the issue that's been happening in recent years in Victoria is that legal aid's funding has been cut. And this has resulted in probably a lack of care given, attention given to cases with young people in them,
mm-hmm.
which is really damaging for these young people's cases because they don't have an opportunity to have a lawyer that represents them fairly and actually follows due process. Even though due process is being adhered to, it's not to a good standard. And that kind of leads on to natural justice.
Yeah.
And it leads to the question of one of the main sort of principles of natural justice is a fair hearing. And are they getting a fair hearing because they're not getting defended properly? So that's a really important part of it and something that's been a really major concern in recent years for young people in Victoria.
Just really quickly then, what's the difference between due process and natural justice?
Yeah, well, natural justice is it's a bit more of a broader term, and it actually refers to looking at ensuring that people's rights are adhered to in the justice system and making sure that they have the chance to hear their case and to have a case that's heard fairly, whereas due process is about the legislation that's put in place to ensure that everyone has access to a fair system, if that makes sense. So due process is about the processes that are put in place to ensure that natural justice occurs. Natural justice is sort of the principle behind,
So can someone have both?
Well, they kind of intertwine in a way that natural justice needs to be created through due process. And that becomes a bit of an issue because due process is made through legislation and through policy. But what can happen is that natural process gets lost in that policy because policy becomes used by the courts on an everyday basis, that the idea of natural justice and having a right to an unbiased trial and a fair hearing, it gets lost in translation because lawyers and magistrates in the court system, they're simply following the policies and processes in place. And while that's the case with, the lack of natural justice being considered, it can actually work the other way around, where if there's too much natural justice, then it can lead to the due process being hindered because if there's so much consideration to natural justice that it hinders the system in terms of, like an example of that would be to adhere to natural justice, we need to make policies and procedures. But if there's too many policies and procedures, then how is the court system meant to function properly? Because there's so many barriers and hurdles that they have to get through.
Sounds like it needs to be a little bit of a balance between the two.
Yeah, it really is. And it's almost the job of magistrates and the court system to ensure that. It's almost like a self-check, and magistrates need to be aware of that. Is natural justice being observed? But is due process also being observed in these cases?
So then in terms of social justice issues, then what do you think young people experience when they're in court in terms of social justice issues?
Well, a major report came out in 2017 called the Justice Project, and that actually looked at the barriers that young people face when they're accessing the justice system. And it was a massive project done, and it looked at groups of vulnerable and disadvantaged people accessing the court system and what are those sort of barriers. And for young people, it was actually about a few different factors that played into it. And a few of those were, of course, the fact that the justice system isn't catered for young people. It's a system that is made for adults, and that doesn't come into a lot of consideration that there are children and young people accessing it, but they're still getting treated as adults. Another one of those is obviously the communication barrier between young people and the court system, because young people don't communicate like courts and lawyers do. They have a different language and different sort of terminology that they use. And it works the other way around. The court system and the legal system has certain terms and words they use that young people don't understand.
Yeah.
And that becomes a really conflicting thing for young people, because they're trying to navigate this system and they can get really lost and confused in it.
So should young people then be treated differently to other people that are entering or attending the court system? Should they be treated differently?
Well, it's actually, yes, they should be. They should be, actually, because young people don't experience it the same way. And young people, another one of the barriers is young people have less psychological development as adults. And this can actually really play into it, because young people can feel overwhelmed by it. And a report by the Create Foundation in 2018 actually found that a third of young people from the out-of-home care system, young people who are really disadvantaged, they actually a third of them found the whole process overwhelming. Like they didn't have any supports, like they didn't have enough information, like they didn't feel like, they had that capacity to be in that system and feel supported during that process.
What about the UN Committee on the Rights of the Child? What did they sort of emphasise in relation to justice?
Yeah, so they sort of emphasise the fact that the court system and young people accessing the justice system need to have child-sensitive information given to them, and child-sensitive procedures and settings put in place so that they can have a fair hearing and a setting that's not going to traumatize them more, or is not going to go against their basic human rights. Because young people don't have that opportunity to experience it in a way that makes sense for them. They're experiencing an adult justice system instead of one that caters to their needs about the language barrier and the the lack of support within that system, the dependency for adults. They need adults there to access it. They need adults to transport them to courts. They need that support.
Do you think that when we visited the Broadmeadows Magistrates Court, that all of these different elements that we're talking about in terms of like what the experience was for the children, like do you think that it was they were being met in a sense, like in terms of what their needs are when they are in the court system?
Yeah. Look, I think in terms of, if you're looking at it from a point of natural justice and due process, they had representation, they had information, but the way that that's delivered, I don't think they had the capacity to understand it. So yes, in terms of their basic legal rights, they were met, but were they done in a way that enabled the young people to access the system in a positive manner?
Yeah.
I don't think that was done when we observed the Broadmeadows Magistrates Courts. The young people got there and they have to speak to their lawyer really quickly, and then they're rushed in and they sit there, and they have to listen to their lawyer speaking to a magistrate in language they don't understand. They might not be able to comprehend what's going on for them, so it can be a really overwhelming experience. And what we observed, I think, was a really good example of that.
Yeah, I mean, I know for me personally, visiting the courts and like sitting in court 6, which was such a busy, overwhelming experience with people coming and going. So I can only imagine how challenging that would be for someone that's actually in that system.
And being a part of that system is even more stressful, where we were there just observing, but having to sit there and hear your case read out and try and navigate that, it can be really challenging.
Yeah, awesome. All right, thank you. Cool. All right. So now we'll have a little bit of a look over the social issues that we saw in that were present in both cases.
Yeah. So how do you think you're going to consider these social issues based on our observations of the cases we saw at the court?
Yeah, sure. Well, I think a good way for us to consider the social issues that were presented in the cases would be to apply some theoretical frameworks. Yeah. So in particular, I think we might look through the lenses of a critical social work perspective and as well as the ecosystems perspective. So I guess, from a critical social work perspective, Fook talks about, this idea of, the consideration of macro level structures, which, can present in terms of cultural, social, economical, political, and those influences and how that might, impact on social issues that are faced.
Yeah. So in terms of these sort of different aspects you're talking about, how can you apply, and with critical theory in general, how can you apply this to the cases we saw? How does the theory translate into the actual cases?
Yeah, sure. So if we're talking about critical social work as this consideration of the broader structural influences and what they're having on the individual, I think, in particular reference to case 2, where we saw that guy who had experienced quite a lot throughout his life in terms of, structural disadvantage within communities. So that included the housing instability, and the magistrate drew on that as a specific, example of what he'd experienced in his life. So, that's definitely something that we would consider potentially from a more structural or a broader perspective, would be the potentially the challenges or the lack of housing in that sense. Also, I guess tying in from that as well could be potentially the result of socioeconomic influences, and that's obviously interconnected with housing, or potentially in this case the lack of and the instability around that as well. I think as well, in terms of drawing on critical social work perspectives and values in terms of how we're viewing these social issues in the cases that we saw, I think it's really important to consider the role of power, and that, the role of power relations in society as well. And again, considering that role of power, we could again be applying that to the structural issues faced by that defendant, particularly again around housing, for example. How
about with the power structures within the court setting itself? Do you think that maybe plays into it as well?
Yeah, for sure. I mean, the whole justice system, right? There's this whole power imbalance there going on, and I think as well, through applying this critical social work lens or this perspective of viewing things as well, it really allows us to understand the influence of those power imbalances that are going on in the social justice system. And as you kind of referred to before about the experience for the individuals in the system as well, I think that's a really sort of, important point as well.
So were there any other sort of social issues that, came up during the observations of the court?
Yeah, definitely. In case 2, again, specifically referring to that same defendant, the magistrate again drew on other social issues, including drug use. So I think that defendant had obviously experienced an ice addiction. I think she specifically referenced.
Yeah, I think that's right.
Yeah. So I guess that's also consideration of another social issue that, you know, the magistrate was able to take into consideration. And on that note too, I guess she really, in regards to the past ice use, she actually made reference to how the defendant had been able to seemingly overcome some of those challenges that he was having in regards to that. So whilst she was pointing it out as a social issue, she was also drawing on the strengths that he had in regards to be overcoming it. And also drug and alcohol counsellor was there.
And it also kind of plays into the Children, Youth and Families Act, because it actually talks about that as well, doesn't it? It talks about the fact that magistrates have to take those things into consideration when they're making decisions. Yeah,
definitely. I think they have a responsibility to do that. So,
so you talk about critical social work theory. What about looking at it from a different lens, from a different social theory, like let's say ecosystems theory? How would you, let's say, apply ecosystems theory to the social issues that we saw?
Sure. Ecosystems is another interesting sort of theoretical framework which we can use to try and understand the social issues that, you know, were coming up in the cases. Connolly and Healy talk about the ecosystems as a theoretical framework which integrates systems which are impacting on clients' lives, and this sort of focuses on the interactions, you know, between various systems and various environments. So this, I think, is particularly useful when we're looking at case 4. Case 4, the magistrate used the reference to the different systems in that person's life. She drew on them as a positive, essentially. So I guess the interaction between the defendant and the systems in that case would apply to his schooling, for example. So looking at the school environment as another system that he was interacting with. She also sort of looking at through the different systems also sort of talked about his role and position within the community, and specifically with that too, she actually, as part of the sentencing, as the others mentioned before, but as part of the sentencing, he was requested to do community participation through work at the Salvation Army, I think it was. And she was, you know, talking about the interaction with that community in terms of bringing to his awareness, you know, what other challenges might be faced by other people. So I think thinking about those various systems that are present in people's lives are really important in terms of also understanding the impact, positive or negative, that can have on social issues.
So case 4 is a really good example of ecosystems, but maybe something a little bit more challenging would be saying, with case 2, how would you apply ecosystems to that? Because case 2 probably lends itself more to a critical social work theory perspective, but how would you maybe apply ecosystems with that case?
Yeah, sure. I think ecosystems is still, you could still use that in terms of case 2 when you're looking at the social issues, because another really important key concept of the ecosystems theory is looking at how individuals fit within the environment, whether it be, you know, a good fit or a not so good fit. And so I think when you're applying the ecosystems perspective to case 2, as we sort of also mentioned in the critical theories perspective, but the interaction that that defendant had with his systems in terms of, like, you know, housing, there was no mention of school, there was like very limited family support. I think it's also equally as, it can be equally as useful in considering the influence of his environment and how we're understanding how he fits within his environment and the subsequent impact that that's having on the social issues that he was experiencing.
Awesome.
So if we also, in regards to social issues, another aspect of that is looking at the adequacy of support available, which we kind of touched on before, but I think we'll look at specific reference to social work. And I think if we're talking about the role of the social worker in the justice setting, we can also draw on the Australian Association of Social Workers Code of Ethics, and look at that in terms of
how does that tie into sort of the justice system and how social workers work in the justice system? It's interesting.
Yeah, well, because the social work mandate, as stipulated in the Code of Ethics, I guess, has 3 core values around around respect, professional integrity, and also social justice. So we're talking about social justice specifically, and that refers to things like social fairness, reducing barriers, which we touched on before, and expanding the choice, for those people who are vulnerable. So they're all things that, as social workers and support workers in the justice system, that we really need to be focusing on. So I think the Code of Ethics is incredibly relevant and important to a social worker's role in the justice system.
Yeah. So within that justice system, in terms of looking at the social worker's role, what social workers were present at the court? Like, how many social workers were actually part of that setting?
Well, that's interesting because we witnessed quite a few cases within Court 6 at Broadmeadows Magistrates Court. The building itself, there were quite a few support services, which I'll touch on again in a moment. But in terms of social work, we only saw the one social worker present for the whole Broadmeadows Magistrates Court, and there was up to like 6 or 7 courts in that facility. So that social worker there worked for the Salvation Army, and we witnessed that on her office door. So I think that's an interesting consideration as well in terms of the organisational context and who that social worker was working for, in this case the Salvation Army, because I think if we again draw back on the values of the Code of Ethics and sort of bringing that into the social worker's role and then the organisational context, they're all really important considerations because the Salvation Army, for example, might have certain values and certain views. I mean, an obvious one with them is like their views on abortion, for example, and like how that potentially can result in biases in certain cases. So I think they're all, whilst there is a social worker present, there's all these other variables that we need to be considering as well.
So what are other supports? So you talk about the social Salvation Army social worker. Were there any other supports? Because it doesn't seem like a lot of support.
Yeah, look, I mean, there were, as you kind of alluded to before as well, like within the youth justice workers. But I think as well, like from the building facility itself, again, as we've sort of said, it's quite a hectic, busy place. But within that building, we noticed that there were family violence lawyer service. There was a mental health advice and response service, Victorian Legal Aid, as we've mentioned, and also the respondent support worker.
So I was just going to ask you, do you think these are adequate? Because when we were there, it didn't really seem like there was a lot of activity coming from those offices. They seemed sort of not a lot of people going in or out. Obviously, we weren't there for very long, but do you think they're adequate, those supports?
Look, I think that they're there, and it ticks the box of those supports being there. But in terms of like how proactive they are in supplying or like providing support, I'm not sure. I think that, as we've said several times too, it was such a busy experience in terms of like the number of cases that were being viewed and so forth. And I think that, to have, say, one social worker and to have one family violence worker who we didn't even really see. I don't know if it is sufficient, to be honest. And I think that with the volume of cases being seen in that place and the volume of people having experiences within the justice system, it doesn't seem like a lot.
Do you think that the youth justice workers, do you think they actually form a part of the support for the young people, or do you kind of feel like they're just part of the system as well?
I think that would probably be a little bit maybe contextual. I think that the youth justice workers are definitely a part of the system, but I think, in some cases too, that they also are part of the support system as well. And I think we witnessed that with the first or the second case in particular, where it did seem to be really quite supportive in terms of like the defendant.
Yeah,
I
and
don't know
really
what-
being active in that as well.
Yeah.
Like the youth justice worker asking the magistrate to actually make decisions and ask them to put certain conditions within their sentencing. So
Yeah,
that
that's right.
They got the right support.
Yeah,
You're right. Yeah.
Yeah.
In that
definitely-
case, I guess they were supportive, but
yeah.
I guess, like, you're right, it's contextual. It depends on the case.
Yeah, I think so. Like, I probably depends on the case. It maybe depends on the worker
Yeah.
as well. Yeah,
Awesome.
great.
Thank you.
Thank you.